Are we starting the meeting? Hello?
We're starting the meeting.
Before we start, I just want to indicate that we are on live stream, I guess they call it, which has been down for about 3.5, 4 weeks, but through the work of all the counselors and the staff at the Governor's Council Office, in coordination with the Lieutenant Governor and Governor and their staff, we've been able to put all the pieces together and get it back up and running. So that's what's new for today. So you'll be the second candidate on the new live stream up, okay? Let me read a letter to the, put in the record, the letter from the governor. April 6, 2022, Executive Council, Chamber, State House, Boston, Mass. Dear councilors, I'm pleased to nominate John P. Pappas to the position of Associate Justice of the Superior Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker, Governor. The vice is the Honorable Robert N. Tuchka. With that, I will ask the nominee if you want to introduce the people that are here.
Thank you, Councilor Jubinville. I'm humbled to be here today. I have a number of people. I have 2 witnesses who will be testifying on my behalf today, Amanda Gibbs and the Honorable James Boudreau. I'd like to introduce my family, my wife, Catherine, my daughter, Olivia, my son, Nicholas, on the other side of the room, my oldest sister, Pam, and then just going around the room, good friend and former boss, 14th District Attorney of Suffolk County, Dan Conley, close colleague and old neighborhood friend of mine from when we were little kids, Rob Satana, colleague of mine, Mark Lee, dear friend, first person I ever met in the District Attorney's Office at the Boston Municipal Court, Peter Flaherty, who's a dear friend of mine, Jim Boudreau, who I produced, a mentor and close friend of mine for many, many years, now an Associate Justice at the Boston Municipal Court, Jim Coffey, the District Attorney now, 16th District Attorney of Suffolk County, Kevin Hayden, close best friend of mine, Chris Sargent, very, very close colleague of mine over the years, spanning 3 decades, and now the Chief of Homicide, Ed Zabin, another close colleague of mine, and probably the secret of some of my biggest successes in the courtroom. He did all my graphics over the years, John Green, Amanda Gibbs' husband, Michael Gibbs. I think that's it. Thank you very much, Counselor.
Okay. So we'll start by having your first witness, Judge Boudreau.
Where would you like me to sit?
Right over there, Judge. I think it would have you back so soon.
It has only been a few months. It's good to see you. So, good morning, members of the council on Zoom as well as presently here. As you know, I'm here to recommend John Pappas to the Superior Court, and I do so without reservation and without hesitation. You know, I've had the good fortune to work with John throughout the years as a colleague, and in that capacity, I've observed his work both as an assistant district attorney, a lawyer, and I've also developed a friendship with John. So I talked about John for a moment as a prosecutor from a defense attorney's perspective, which is what the role I had for many years. I knew John and tried cases with John for approximately 20 years. And I have to tell you that he was a stellar prosecutor, a person who was fair and respectful to everyone that he dealt with, both from the defense side as well as from his own side when he was with the victims. Coming across, as you all know who work in an office, in Boston, you come across a whole different array of people, socioeconomic backgrounds, racial backgrounds, and John had nothing but the greatest respect for all the people he dealt with, and I watched that firsthand. In terms of his preparation, I know that his graphic person is here. I'm finally able to meet him personally, and I know that John has benefited from that because the work that John did in the courtroom was nothing less than the best. I was up against him on 2 serious homicide trials and have had other cases with him. And he is, I have to say, and I apologize to his fellow prosecutors who are here, he outshone everyone when he was inside the courtroom. And he was always prepared, articulate, and again, respectful. As the prosecutor, I always found him to have the highest level of ethics. And I say that personally because when we're dealing with those difficult cases, the homicide cases, it's incredibly important to be transparent, not only so the case doesn't come back and haunt you later on, but also because you want to make sure that you're doing the work at the highest level. And John always did that. Never had any concerns. He was always transparent with me, always had an open file before that became a kind of a necessity. And John always was somebody who brought to me any concerns he had about witnesses in advance. No issues regarding his ethical abilities in that area. John is extremely intelligent and prepared, but intelligent. And not only that, flexible. You see him in the courtroom pivot. You see him be able to make arguments under fire. And in addition to that, was somebody whose demeanor was always balanced. And as you know, when we're in the pitched battle, there's an opportunity to get out of control, to lose one's temperament. Never happened with John in the cases I was with him. And I say that personally, but I also speak to my colleagues in the defense field who all said the same thing about him. There was never a complaint about John in any respect. In fact, he had the highest respect from all my colleagues. And ultimately, beyond being well-balanced and a good temperament, John had good decision-making skills, again, in the pitched battle, but also with trying to resolve cases and working with the judges and making arguments, never overplaying his hand, but also understanding that it was necessary for purposes of justice and for resolution of cases. And I think all those qualities are critical for a judge in the Superior Court, but not all people have them. It's part of John's DNA. And I think he's an excellent candidate for the bench. And I'm not friends with every assistant district attorney. I have a number of people that I've become friends with, but I am with John partially because of mutual respect for each other, but also he's a good person. He's a person who I've always thought makes good decisions, but also does the right thing. In the end, does the right thing. And frankly, has a pretty good sense of humor. I've always enjoyed that about John. And again, these are innate qualities that can't be taught. He has trust. He has a trust of his colleagues being placed in the positions that he's had. And he has, I think, the trust of the bar. And ultimately, he's a fair and reasonable person. And although John has not been a civil practitioner, he does have the flexibility and intellect to make that transition. He is a trial lawyer by nature. He's, as I said before, intellectually flexible, understands the rule of evidence like a law professor, and is efficient and well-reasoned both as a researcher and as a writer, which I've seen both. So I have no doubt that John will adapt quickly to the civil work that faces him. In my opinion, that's not a barrier at all. I'm aware that the governor's nominated a number of prosecutors for this position in recent years, but John is different for the reasons I've spoken about already. He's a stellar nomination. I think that will make every counselor proud if you confirm it. So thank you.
Thank you very much for your words. Yeah, Councilor Devane.
It's been a long time.
Has been.
No, when was it? How many years ago?
Well, no, it's not that long. October. October. It feels like it during the.
You haven't come to visit us since then.
It's good to see you. Liz.
No, it's such an honor to have you be a witness for the nominee. How long have you known the nominee?
Mr. Pappas, for at least 20 years, if not
Oh,
longer.
no. You know, that means a lot to me because I've been here 22 years, as you know, and I've had people that have come as a witness and I've said, you know, how long have you known this nominee? Oh, I saw him once in court. That doesn't, what you said was from your heart and you know, and I think, you know, you saw the person that he is too with his family and all. Do you want to talk about any of that?
Well, I mean, in terms of my friendship from John, you know, we're not, I'm not the type of person that necessarily
Yeah.
has,
But you know, he's
trips
committed.
outside of the court, but I do know, we talk about his family. I know how committed and loyal he is to his family, and what a good family man he is.
Right, right. Well, it's so good to see you and you're doing good things and you couldn't have been nominated at a most difficult time through the pandemic. So thank you for all your service.
Yeah,
Mr. Chair, if I may,
Councilor Kennedy.
Judge, it's good to see you again. Judge, I just want to say something about a comment that you made about the governor getting a lot of criticism for putting too many prosecutors on. I agree with you that he has gotten a lot of criticism for putting too many prosecutors on, but I disagree with the premise. I think if people look at the numbers, they'll find that it's pretty well balanced between prosecutors and defense lawyers. It's something that we as a council have pushed back on, and I think that we've gotten some results from that. I think there have been a pretty fair number of people from the defense bar. I also think part of it is the problem is that, you know, people who've been prosecutors and then defense lawyers are labeled as prosecutors forever. We had a nominee this morning who was a prosecutor for a time in Suffolk County and then went into defense work. I wouldn't label her as a prosecutor. So I disagree with that. I don't think that it's a situation where there's been too many prosecutors. I think it's been pretty well balanced.
And I don't disagree with that. I'm a defense lawyer by trade, and I was nominated and confirmed by this. That wasn't my suggestion at all. I just I want to make sure that everybody realized that John was a standout as a prosecutor.
No, I agree with that, but I just wanted to correct the record there. I think there have been a lot of members from the defense bar that have been nominated under the Baker administration. That's all.
Thank you, Councilor Ino.
Thank you, Judge.
No questions, you're doing a great job, and glad to see you again.
Judge, can I just ask you a question?
Sure, I'm sorry. I didn't mean to.
How many years did you practice criminal law?
I practice approximately 30.
So, to me, your testimony is really important because you have done so much trial work and you get to know DAs over the years, and I'm sure you wouldn't be here if you had any doubts about this nominee.
Absolutely not, without reservation or hesitation.
And how have you made the transition from lawyer to judge?
I think, from my opinion, well, whether or not the bar thinks that, but I think it's been a natural transition for me, as I think it will be for John. I think the support of the colleagues and the program they have is excellent. So I think Mr. Pappas will do well.
Where are you sitting?
Woburn right now.
Good for you. Thank you very much for coming.
Anything else?
Amanda Gibbs.
Good morning, everyone.
Good morning.
Thank you for having me here. I'm just going to read something I have sent. I have known John Pappas for about 5 years. We met as a result of the murder in Boston of my goddaughter, Dr. Lina Bolaños, and her fiancé, Dr. Richard Field, on May 5th, 2017. John Pappas was the Suffolk County District Attorney who tried the criminal murder case against Texera. There are two sides of my discussion about John Pappas. The first side is his knowledge of law and professionalism. During the course of the year prior to trial, my husband, And our family and the family of Dr. Field attended numerous date updates, meetings with John Pappas. John clearly explained legal issues of the case and always took time to listen and answer our questions. John's attention to every detail of the case, I believe, left no stone unturned, finding all facts related to this case. He worked closely with Boston detectives who gathered various pieces of evidence. John always invited the lead Boston detective to these meetings, and we were able to ask questions of him. John said to me that attention to detail is very important if an appeal of conviction is ever heard, and the importance to rule out any missteps or oversight of the prosecution process. I attended all days of the trial. During the trial, I observed John's complete knowledge of facts and his methodical attention to detail of presentation. He is truly a master of his job. The resulting jury verdict was guilty of first-degree murder with sentencing of life imprisonment with no parole possibility. Now, there is the second side of John Pappas I want you to know. These murders were devastating to our families. What makes John so special to me and our families is his outward compassion, empathy, and understanding that this was not just an exercise in giving a conviction, but acknowledging how it deeply affected our lives. John was sensitive to our grieving and the brutality of the murders, and he sincerely wanted justice done for us. I believe that John Pappas would be an extraordinary addition to the Massachusetts Court as a Superior Court judge. I believe he is dedicated to always doing what is right and just. Thank you.
Thank you very much, Councilor Devaney.
I'm sorry, I didn't hear the name of the victim. You tell me?
So this happened May 5th, 2017. My goddaughter, Dr. Lina Bolaños, and her fiancé, Dr. Richard Field, they were murdered in a penthouse in South Boston. So,
They're doctors.
yes.
Yes. I will never forget that case. I'm so sorry. To have someone that's compassionate that you could go to, and you did say that he called you and kept in touch with you.
He made the transition of this grieving to be, it's not going to go away, but he made it so that we felt he was really there, as if he was part of the family of.
I mean, he never get over that grief, but thank God the justice that he deserved.
We couldn't have any better person.
Yeah.
The family sends their regards.
Thank you so much. Your testimony meant so much, really.
Thank you. It was my pleasure to be here. Anything else?
Thank you very much. Well done. We're going to have Dan Conley say a few words.
Thank you, Councilor Jubinville, and councilors that are present, councilors that are here on video link. Yeah, it's really my great fortune and privilege to have a friend like John Pappas, so really happy to be able to say a few words I sent over. And not to belabor the point, but, you know, for the better, I met John actually when he was a law student and I was a young DA. But we really got to know each other during my nearly 17 years as the Suffolk District Attorney. During that time, John was one of my closest confidants, advisors in that very important role. And over time, we developed a close professional and personal relationship. So, Councilor Devaney, I mean, it's been said by Judge Boudreau and many others. John's legal abilities are unquestioned. I mean, incredibly talented litigator, knowledgeable, knows the rules of evidence inside and out. So that piece of it has been said and said very well by others and clearly. But I'll just talk briefly about John the man. Over those nearly 17 years when we became close friends, we had many conversations both about our work, the role of the prosecutor in this criminal justice system, and conversations about our kids. My kid's a little bit older than John's, going through the period of growth as children and then adolescents and athletes and whatever you have it. John, somehow was able to build and develop an incredible professional career. At the same time, an incredible husband and father to Kathy and the two kids. They've been over my house many times, and I've got to know them well. He loves them with an unquestioned a depth and unconditionally, and they know that. They see him. As a leader in our office, John is not using a sports analogy because he's an athlete. Using a sports analogy, not the kind of guy in the locker room that's going to jump up on the bandbox and start screaming and cajoling the other players to play well. John simply carried himself in a way that everybody wanted to emulate him. He was just a consummate professional leader in our office. When I was district attorney, I asked all of the leaders, Ed Zabin, Mark Lee, Josh Wall, Pat Hagan, Dave Deacon, who are now all judges. Yet, not Mark yet, but hopefully one day. To be trial lawyers too. It's very easy when you rise to the level that they rose to kind of put the trial work aside, but I never wanted that. That's why on the Texera matter, we assigned John to the case, the most complex, the most difficult, the most challenging work, as with the other gentleman that I just mentioned, and others in the office that are here. And so he had the overall supervision of all the trial work in the office, plus his own caseload. And, to say that I couldn't have done it without him and some of the others in this room is really an understatement. I'm just privileged to have his friendship and to see him rise to this level. There is a few lawyers more deserving for this honor, and I know that John will do a tremendous job. What's most important to me in a judge, frankly, is the way they treat people. And I think there's no question John is going to treat every person, litigant, defense attorney, prosecutor, civil litigator, witness, with the highest level of respect and fairness and good temperament. And to me, that's very important. So I appreciate the opportunity to say a few words on John's behalf. And if you have any questions, I'm happy to take them.
Thank you. Go ahead, Councilor.
I'm proud to say you're my friend. We served on a board, and I was very proud to be a member of the Commission for Social Justice of the Sons of Italy of America, which was established over 35 years ago to stop stereotyping of Italians and recognizing outstanding Italian Americans in Massachusetts. So I wanted to say that because you wouldn't say it. But no.
I didn't know I was Italian until you.
No, you like my kids, But I just wanted to say that your letter, it was so heartfelt that you really know this person personally and professionally. And what you said about him, how his knowledge of evidence, unwavering ethical compass, and shown again to know the complex issues and all of that. And what I loved what you said was that John is there for those who struggle, toil, and labor in life's margins. And the combination of allowing him to investigate and prosecute some losses. When I met with him, I knew those cases, they were profiled, and I couldn't believe that he had all of that, background. And we need that. We need his life experience to bring to the judge. when you think of all of the cases that you had when he was working for you, is there one that stands out that he was remarkable in that case?
Well, one of the things we always talked about when I was district attorney, and I'm sure District Attorney Hayden emphasizes the same thing, our job is about serving victims and then holding criminals accountable for their actions. And one thing that John was really well known for, and as previous witness testified to, is just, the ability to fully identify with victims of violence and their families. Sympathy is when you feel an emotion for someone else. Empathy is when you can actually stand in their shoes and feel it. And John was like that. And we both can cry at the drop of a hat, so I don't want to do that. But when his father was hit by, out on Center Street in West Roxbury, I think in some ways it changed John. Even he was an empathetic guy already, but having, lived through the violence that his father had to deal with. And, it just really changes a person. And so no one case sticks out, but I think as the previous witness said, he understands and lived that experience so well that he could identify with it, and he treated everybody the same, any victim, any family. So proud of him for that.
But I want to thank you for your service. They couldn't replace you, and we missed you when you left.
He's doing a good job.
No offense, no offense. Yeah, I haven't had the opportunity to be here yet, but I just, you served with empathy, with compassion, and knowledge, and we'll never forget the service that you gave. So thank you, and your testimony means an awful lot, really.
Thank you,
does.
counsel.
Thank you.
Thank you.
Thank you. Thank you, Dan. Suffolk County District Attorney Kevin Hayden.
I'm so
Oh, no offense taken. I'm just getting started.
But, yeah, but you were not the immediate, okay, so I
No,
didn't mean you.
No offense taken whatsoever. Thank you.
Wasn't you?
And thank you for the opportunity to come up briefly and speak on John's behalf. I wasn't prepared for this, but I'm really honored and humbled to do so. So, when I was in the DA's office, I was there from 1997 to 2008. John was always there. John was always there when I was there. And he was always ahead of me. And I always watched him, admired and esteemed how he did his job each and every day. DA Connolly referred to him as a leader in the office, and he has always been a leader in the office. He's always stood out amongst prosecutors as stellar, attentive, compassionate, brilliant trial lawyer. He did it all, and I always admired and respected him for that. And, he's still there. He never left. I left, I came back, he was still there. And that's a testimony to his dedication as a public servant. I will say this, and I didn't know John as well then as I do now. But even back then, what stood out to me about John was I knew it was obvious. It sort of poured from his veins to an extent. He is a family man, and that was always obvious. His love for his family and for his wife and his children was always obvious. And that love for his family extended into the office. It extended into the community. It extended into the cases that he handled. And it's that compassion and love that he had for his family that just exuded in pretty much everything that he did, in every case that he tried. Very even-keeled is a very good way to describe John. I don't think I've ever heard him raise his voice, not ever. I'm sure he probably has, but I haven't seen it. He's always been a temperament, both in and out of court, always impeccable, extraordinary, and above reproach. But I guess I could say two other things about John. One is that Since I have come back to the office, his leadership, his friendship, his fellowship to me has been immeasurable. I have relied upon John in many, many ways in a very short period of time since I've come back to the district attorney's office as a DA. And I don't know if I would be as even keeled as I am if it weren't for having him by my side. I talk with him regularly. I meet with him regularly. His wisdom, his advice, his support of me has been implacable, and just means so very much to me. And so a friendship that was existed before has become all the stronger in a very, very short period of time. And I just want, John, you to know how very much I appreciate you. And I guess the last thing I would say, and this is, I think, the best way that I can describe John, and I say, I don't, when I say this, I don't say it lightly. It's not a term I use often, but I would certainly use it to describe John. He is, simply put, a man of honor. And as a man of honor, I know he will make a good and honorable judge. Thank you.
Well, we can have him go back to Suffolk County if he comes in.
No, I'm not. I'd never hold any. Believe me, I'd love to have him back, but I'm not going to hold anyone back. He's going to make a great judge.
Thank you. Thank you very much.
He deserves him. He really does.
Very much.
Thank you.
I just have one question. Can you think of one adjective to describe this nominee, what he'll bring to the bench?
Yeah, I think it's the one. Well, I'll use two because I already used one. He truly is a man of honor, and I don't say that about many people. But he's compassionate. The former DA, my boss, used the word empathy.
And I've often said here that I would never vote for anyone who doesn't have compassion.
Yeah, well,
And he certainly has shown it through the years.
he's got it in spades, and it shows up in each and every case. It shows up in the way he treats each and every person in the courtroom, whether it's the defendant or the victim or the witnesses. Everyone is a human being worthy of honor and respect in his eyes, and it shows in everything that he does.
Well, thank you for your service.
Well, thank you. Yeah, likewise. Thank you so much.
Thank you. That takes care of the witnesses on your behalf. Anybody here in opposition? Anybody here in opposition? Hearing nothing, we'll hear from you.
Thank you, Councilor Jubinville. Just, I'm a lucky guy. I'm a really lucky guy. And I'm going to try and keep my comments brief, but it's and I will.
We love the rule of brevity up here.
It was a struggle to try and compress 28 years plus into the comments that I'm about to give. First, of course, I have some people to thank. I want to thank Governor Baker and Lieutenant Governor Polito, not just for showing the confidence in their nomination of me as an Associate Justice of the Superior Court, but before that, back in 2018, when Governor Baker appointed me District Attorney to fill out the remainder of Dan Conley's term. And then in 2022, for further considering me for the appointment, which ultimately went to my good friend, Kevin Hayden. I want to thank the Governor's Council, and especially you, Councilor Jubinville, as my host counselor and my district counselor, for being so generous with your time and so accommodating to help guide me through this process. And I want to thank the other counselors that I've had the opportunity to meet with in person or over the phone, or to set up time after today's hearing to the extent they feel it's necessary to speak with me about my nomination. It's kind of an unusual position that I've been in. I've told a number of people that I was more nervous coming into today's hearing than I've been in giving any opening or trial in some of the biggest cases I've had over the last 10, 20 years. And one of the reasons for that is because those are all known factors and things that I can control. And this is an unknown for me going through this process. I want to thank the Judicial Nominating Commission and their staff, the Joint Bar Commission, Governor's Legal Counsel, Bob Ross, my good friend Lauren Green Petrino, who's been a friend of mine for years and has been so helpful throughout this process, along with her staff. You know, there are so many people that I've had contact with over the years, and I've been so lucky over the years, 28 plus years. My best description of my job is that it's never seemed like a job to me. The trial court staff that I've met, clerks, court officers, court reporters, you know, the staff that would be coming through the grand jury offices on the 6th floor when I'd be there at 10 o'clock at night on trial that I developed relationships with over the years. Just too many to mention. Members of the judiciary, former colleagues of mine who've now become judges, defense attorneys who become judges, all who reached out to me after my nomination and stayed in touch with me and were so supportive during the process. Probation officers, and of course, law enforcement from the Boston Police Department, Massachusetts State Police, Transit Police, Chelsea, Revere, and Winthrop, all of them. And last but not least, all my colleagues in the Suffolk County District Attorney's Office. My extended family, you know, assistant district attorneys, good friends, Ed Zabin, Mark Lee, you know, so many, just they're here today, but so many of them over the years that we've gone to battle that I could rely on for different issues. You know, help me with this. I've never seen this before. How do you think this will play out in court? You know, am I doing this the right way? You know, without their support, I would not be sitting here today, frankly. The victim witness advocates, support staff, investigators, technical and trial support. When it comes to doing some of the cases that I've done over the years, I'm not the reason for the success alone. All success is shared, and they were truly team efforts. And I always analogized at Councilor Jubinville to when one of these cases happened, from the point of incident, it would be like assembling and running a small business from the point of incident to verdict. And all the personalities that you had to manage, all the people you had to meet, what their roles were, what their jobs were going to be during the trial, how you managed evidence. It was truly like running a small business, and we always took a team approach to it. And I was fortunate that I had great teams to work with. Yeah, I was the guy in the courtroom presenting the case, but that's not possible unless you have all the people putting in the sweat equity behind the scenes, putting in late hours, coming in on weekends, dealing with my impossible standards until we had it just right so that the jury would see exactly what we wanted them to see in a courtroom. Again, all success is shared, and you know, everyone was valued. How lucky have I been to work for the district attorneys that I did over the years? Ralph Martin, who I'm still friendly with, gave me my shot when he appointed me on September 12th, 1994, and I remain friends with him to this day. Dan Conley, who inherited me as one of Ralph's staffers, and I had been in the office about 9 years at that point, and not only kept me on, but just elevated my career and took an interest in my career, and was a major reason for the success I experienced over the next 20 years in the office. Rachel Rollins, who kept me on when she assumed office, allowing me to serve and to complete the prosecution of Pullman Texiera, and Kevin Hayden, who's here today. And, you know, my career, Counselor, is simply a byproduct of the people that I've been fortunate to work with over the last 28 plus years. I've had great teachers and mentors every step of the way who taught me so much about what it is not only to be a good trial attorney, but how to do the job the right way, how to treat people fairly, how to handle evidence, how to never hide the ball on anything, and to be transparent. I've had so many great, you know, mentors, great friends. I mentioned Pete Flaherty, first guy I met in the Suffolk DA's office at the old BMC in the bullpen, where we had, I think, 14 or 15, 16 prosecutors in that room. And School was in session, everyone left the room at the same time and went up to the sessions and then would come back down. And what an unbelievable group we had. From 1994 to this day, one of my closest friends, and without him, I would not be here today. Justice Jim Coffey, another great mentor for me, who taught me in preparation for a trial. If you want to do major cases, it's all in the preparation. And an expression that he's had in that I've always abided by and I've always applied to the work that I do. John, it's 80% preparation and the last 20% is execution in the courtroom. I've lived by it. You know, Kevin Mullen, I don't think is here today, the first assistant, and of course, Ed Zabin and Mark Lee, that we've had, you know, many cases with over the years. Some people that couldn't be here today, you know, Bob Tochka, David Meyer, and Pat Hagan. I'd be remiss if I didn't mention their names today, Councilor Jubinville. You know, having Kevin, you know, I didn't have him originally on my witness list, Councilor Jubinville. I'm so happy that you had him come forward and be heard. I feel like I've come full circle in the office. With DA Hayden now, who I've known for years, I feel that the office is in good hands with him. Kevin Mullen is the first assistant, and I know if given the chance, he'll take the office to newer and better heights. I've introduced my family. My wife, Catherine, who many of you might not know, is a very successful attorney and has her own practice. She's a shareholder. They have offices in Wellesley and Rhode Island. She was a partner at a firm before going off on her own and setting up her own firm in the civil litigation insurance defense section. Her support for me has been unwavering over the years. Every trial I did, I mean, there wasn't a thought, an opening that I thought of or a closing that I thought of that she didn't hear first. The way she was able to hold down the fort with our kids when they were younger, when I was on trial, and I would get that look in my eyes, and she just said, just go, you know, we'll see you when you're done. And, you know, whether those were, you know, 12, 14, 16-hour days, 7 days a week until we brought the case where it needed to be to verdict, she was always there and so supportive, not just throughout my career, but throughout this whole application process to the bench. I would not be the lawyer I am, and I would not be the person I am without her. My two kids, Olivia, you know, graduate of Boston Latin School. She's going to be graduating from Boston University next year with next month with her degree in education. And she aspires to be a teacher, hopefully in the Boston Public Schools. And my son, Nick, another Boston Latin School alum. He did a postgraduate year at the Winchendon School, and now he's attending Bentley University. He's a freshman there. My sister Pam is here today, my oldest sister, who, you know, through some really difficult times in our family was really the quarterback and the backbone, you know, setting up long-term care plans and, you know, keeping everyone involved and our spirits high during those really tough times that we couldn't have done without her. My brother Pete, my younger brother Pete is here, you know, who, you know, the best brother a guy could ever ask for. Always has taken an interest in my work, always supportive, always, you know, when our parents were sick, was right there, no matter how busy he was trying to run his own business, always right there, forever. And the people who couldn't be here, my mom and dad, I would like to see their reaction. They probably wouldn't believe it that I'm sitting in this chair today, because sometimes I'm sitting here and I can't believe it. My mother's sister, my Aunt Helen, my mother-in-law, grandparents, aunts, uncles, and cousins, and in-laws. So many friends and colleagues. I wouldn't be here today without their friendship, guidance, and support. I'm a lucky and blessed man. You have my packet, counselors, my application packet, outlining all my qualifications. And I'm not going to certainly go through that. ad nauseum. A little bit about how I arrived here today, really was quite a journey. I had parents and grandparents who came from small villages in Greece, making their way ultimately to West Roxbury from Canada, Utah, Roxbury, Rosendale, and ultimately in West Roxbury. My mom and dad, Nick and Rose, raised 4 kids in West Roxbury. My sister Pam, my sister Valerie, myself, and my brother Peter, where we have always been very close, and I think we've gotten closer as we've gotten older. My dad started his own appliance business in the Roxbury section of the city of Boston that was ultimately taken over by my brother Pete, who runs it to this day. And my mom was a homemaker, always there for us, raising 4 kids, and always putting us in position where we were never afraid to try something, never afraid to fail. I myself am a product of the Boston Public Schools, having gone to the Randall G. Morris, Solomon Lewinburg, and Mattapan during busing, graduating from Boston Latin School in 1982 and UMass Amherst in 1986. From there, I started off on my work history, working for the Suffolk County Sheriff's Department, a small law office on School Street in the old City Hall building, where I met Peter Flaherty's dad, Francis X. Flaherty, years before I met Peter. And then clerking full-time at Parker Coulter Daly and White at 1 Beacon Street while I attended New England School of Law Knights, graduating in 1993. I was admitted to the Mass Bar that year with aspirations to join the Suffolk County District Attorney's Office, which I ultimately did in 1994, and then forged my career, for the next 28 plus years through that office. I'm proud to have served under multiple administrations and proud of the body of work that I've built over nearly 3 decades. The work and the cases that I've done have not only made me a better lawyer, but more importantly, made me a better person. A couple of things that have always stood out. We encounter people, especially as we get into the more serious victim cases, and in my cases, homicides, people who find themselves literally staring into the abyss, and yet they have the ability to conduct themselves with such dignity and grace. The strength they have, to me, that I've seen case after case has just been so unbelievable. And it's never lost on me that our greatest successes as trial attorneys almost always come on the heels of someone's greatest tragedy. I'm incredibly humbled to be here today. If confirmed, I'll bring to the bench the same principles that have guided me in my career as an assistant district attorney. I thank you all for your time and careful consideration of my nomination, and I look forward to answering any questions. Thank you very much.
Thank you. The counselor's job is to do their due diligence in any way they feel they need to do. Some meet with people, some do call people in that you put in your applications and so forth. So most counselors are pretty well advised about you before the hearing begins. So about a month ago, we had a vote to change the process a little bit to give every counselor 15 minutes to ask their questions because they've done their due diligence, most of them already. So we're going to start the process doing that. Councilor Devaney.
Thank you. First of all, I want to thank you for allowing 20 people. This is great. Last week when you presided, Judge D'Angelo was told no one comes. So I'm glad we're back to a democracy.
That was my decision.
Okay. I just want to say that thank you for coming. It was a busy weekend. Patriots Day weekend and you came. And I have to tell you, it was so great. I mean, first of all, there was more great people in that time that came over to you. It was really, you were a hero. So, and I want to wish everybody a happy Easter next Sunday. So thank you for all your time. I don't have a poker face, and the example of what we need in the court. And I have seen you vote here, and I have voted no, not all the time, but I vote no on someone that's not qualified. And that you are the role model for what we need. And we have some good people that come squeeze through sometimes. But anyway, I want to tell you, Councilor Iannella voted I'm sorry, Council Ianella graduated from the same prestigious high school in Boston that you did. And I have to say, I always thought, wow, you have to be pretty smart to graduate from that school. So anyway, having said that, yeah, I mean, talking with you, I mean, I cry half the time meeting with you. I don't know how, and you can't even count how many cases you've had, how many trials, but I thank you. And you have really made a mark, even a legacy against drunk driving and what you did. And I want to say these things, and we're timed, which I voted against. I don't think you should be timed. I think everyone should hear everything you have to say. But it was 7-1, so on the tuxedo with brown shoes. So, having said that, I'm going to say these things, and then I want you to reply till they sound the bell. Okay, first of all, the drunk driving, you know what I mean, that one. Okay, the other one is about Jermaine Rucker, Amy JNC. I didn't hear the result, and when I met with you, I didn't ask. Sean Waters broke my heart. His fiance said, I will always be his fiance, his wife. Okay? We talked about Dr. Field and Dr. Belask, and we got a letter. His brother, heartfelt. I mean, these tragedies, so egregious. The state trooper that was involved with Santos Laboy, that was humility, humility. And so the other thing is that Amy Lord, oh my gosh, I want, you have done an article, a writing, so I want you to tell us about that Rufo versus inmates of Suffolk County Jail. I think that's very important. So we don't have much time. We have to talk fast because we're on a timer. So if you can remember the things I'm asking you, I would love you to respond.
I'm going to try. So reverse order. It was, you know, the article that I wrote that was published in the Journal of Criminal and Civil and Criminal Confinement at New England School of Law. My first year out of college, I actually worked at the Sheriff's Department, which you know, a few years later gave me the inspiration to write that article that wound up being published. Go figure. That was just a unique opportunity, and I was lucky to work there because you know, it kind of, you know, fueled the fire and inspired me and led me to the decision, if I go to law school, I think I want to work in the district attorney's office. That, you know, I was able to realize that a few years down the road. And I met a lot of great people at the Sheriff's Department who helped me out over the years with transportation issues regarding witnesses and defendants. And I'll tell you one great thing, you know, there was a guy down there, and Dan knows him well, Joe Casey, wound up being a lieutenant. There was never a defendant I had to wait for at Suffolk Superior Court. They were always there on time. I've been lucky, you know, the cases I've done over the years, I don't want to rehash them. You know, William Powers was the Sean Waters case, which was just a tremendous tragedy for the Parlon family and the Waters family and all the girls who were injured. The silver lining out of that cloud is that case was featured, and Tom Brokaw did a special on it, and it was called Sudden Impact. And to this day, people still come up to me. It showed in driving school classes, driver's ed classes, on the perils of drunk driving. And I've had a number of parents tell me that their kids have seen that video in their driver's ed classes. You know, again, you know, our greatest successes come on the heels of someone's greatest tragedy. You know, cases like William Alamany, you know, who murdered tragically, I would say, Amy Lord. I was lucky, you know, tremendous investigators assigned to that case who just did the real gritty work out there on the street, and you know, delivered to me just a great case to try in the courtroom. You know, over the years, Counselor, where
people don't know, if you can just say about Amy Lord.
Yeah, she was abducted from the vestibule of her apartment in South Boston on Dorchester Street and driven around to various locations, forced to make withdrawals from from her bank account before she was driven over to the Stony Brook Reservation, and where her life tragically ended. It was just, maybe one of the most important cases I ever tried for a number of reasons, but, her parents who I spoke to recently, her mom, Cindy Lord, just, the most beautiful people you would ever want to meet, strong people, gracious people, and, how they were able to navigate that and how their resolve was strengthened during the course of that trial. I don't know how they ever got through it. I'm just thankful we were able to get them the result that they were looking for on that particular case. There are a host of other cases, Counselor. I'm not, I've done a number of police-involved shootings, resulting in deaths. I started doing those. It was an opportunity bred out of necessity when I actually started doing those. I think in 2007, that's when my dad was tragically struck by a car, and my whole trial schedule, my world was just completely disrupted because he was catastrophically injured back in October 13th of 2007. I'll never forget the date, but as luck or fate would have it, I remember meeting with the district attorney, and he said, well, we have these other types of investigations that we want you to spearhead. They're not necessarily going to be, require you to be going to court every day or the grand jury, but they're going to require really, really in-depth investigation. I think I wound up doing, 2 or 3 of those in succession, and until finally I was able to get my trial feet back under me in 2010.
Well, Dan Conley documented about the state trooper, that case, and we have it here. That was, we hear those things and we just can't believe that it's really happening, So, how did the Jermaine Rucker resolve? How did that resolve, that case?
That was first-degree murder conviction, and Kentel Weaver was convicted of that, and ultimately that case, believe it or not, that case wound up going to the Supreme Court of the United States on a courtroom closure issue, and I wound up going down there to see the arguments, which was just an unbelievable experience, and we prevailed on that.
Can you tell us any more about that? Your writings, that is really interesting. Inmates of Suffolk County Jail.
Yeah. I'm happy to give you a copy. I brought one today. I haven't read it in a long time, so I'm not going to autograph it, but here's a copy for you, Counselor. I've always felt I've been a good writer. I put together a piece of work that was selected for publication. It looped back into my experience at the Sheriff's Department, and I was lucky enough to have it published, and it's a piece of work I'm proud of to this day.
You said that this was the need for balance.
Right. There was the issue was modification of a consent decree. It had to do with the housing issues that the sheriff was wrestling with for a number of years, whether detainees should be double bunked or single bunked, and spanned a number of years at the Charles Street Jail, and then when they ultimately opened the new facility, the Nashua Street Jail.
I think this is valuable. Perseverance pays off in battle to modify consent decree. New England Journal on criminal and civil confinement. How do you feel about bail? The changes in bail, or do you think there should be more changes?
I think it's an issue that is within the proper discretion of a judge. You see, those are issues that, day in and day out, the back of the system, the district courts, we have a lot of, fantastic judges in the district courts who are able to exercise their discretion on questions of bail. I think it's a little more, a little tighter. There were fewer cases to consider on that issue, but, there has to be that flexibility from the bench.
I mean, there's people
impose bail and when to not impose bail.
I mean, there's people that don't have the money for bail, right? And so what happens?
I don't think people should be penalized and bail should be set in a dollar amount that they can't reach. It should be commensurate with the nature and facts of the case before them, their criminal history and whether they pose, a danger, or threat to the public. And, want to make sure that if there is no bail imposed, that they're going to be coming back to court for their next court date.
But I have to tell you, the letters that we got were really, from their heart. They knew you and they knew what you have done. And I would ask the presiding counselor to, to comment in the comments that were made from the letters, because I'm violating the council's rules because I had talked too much and you had talked too much. So we went over our 15 minutes, but this is valuable. I don't want to take it from you. Do you have an extra? Oh, thank you. Thank you very much. But again, it was such a pleasure meeting with you. I am so happy that the governor appointed you. I'm glad that you applied first time. I can't believe it. And you have the age experience, everything that you've done with, in your community, in your church, with your family, and obviously in the judicial, community, you are so well respected. And I'm so pleased that I had the opportunity to take that time and that you took the time to meet with me. So
Thank you.
Congratulations.
Thank you very much.
Counselor, I know.
Thank you very much. Yeah, you have the whole package. I did get a call during the week from Dan Conley. Great deal of respect for him. He's a great guy. He's a good friend. Also, another person who called me, I spent a lot of time on the phone with him, David Eisenstadt. Great guy. Thinks the world of you. Clearly, from the witnesses that I've heard today, your presentation, your counselor at Jubinville is a big supporter. I don't have any more questions. When you come before the council, I'll be more than happy to support you.
Thank you very much, Counselor. I appreciate it.
Counselor Kennedy.
Hi, John. How are you? It's good to see you. My apologies for not being there in person. It's extremely rare that I am not there in person. We don't usually come on vacation week. We kind of have a backlog of nominees that we're trying to catch up on, and both Councilor Duff and Councilor Jubinville asked if it was okay to put it on during school vacation week. My wife teaches, so that's the only time we can take some time off. I have a couple of questions for you. Obviously, we have spoken a lot. We spent a lot of time together on Friday. We spent some time on the phone, and I've known you for a couple of decades anyway. So I'm going to limit my questions. My first question is about the process that you've gone through in terms of the governor's council. How do you think that you've been treated by all the council?
I mean, me personally, fantastic. Look, I haven't had the opportunity to speak with everyone. I've known Councilor Jubinville for many years. I've known you for many years, as you just stated. I've had the benefit of being in this room on I don't know how many occasions to see colleagues of mine go through the process and get elevated to the bench. So again, it's a little bit surreal for me to be sitting in this chair today and be actually going through it. But I appreciate all the time that the counselors have extended to me to answer questions and to be available and possibly to ask questions of me next week for those who aren't present or able to be here today. So if you're.
Let me ask you this, John. The questions that you've been asked, the vetting you've gone through by the council, would you consider it appropriate?
Excuse me, I couldn't make that out. Can you ask me that again?
The questions and the vetting that you've gone through by the council, would you consider it appropriate?
I would, yes, yeah. I have to know.
We've received a lot of criticism in the last couple of weeks. And I just want you to comment on that in terms of the manner in which your nomination was handled by the council, if it was professional and appropriate.
I mean, one of the first calls I got was, and again, I'm talking from my own experience with my host counselor, my district counselor, Mr. Jubinville. I have been treated fairly, and I've received a lot of positive feedback to the point where I would be thinking to myself, something must be wrong here. Things can't go this smoothly, but if you're asking me if I have a criticism of the process or how I've been treated, no. Counselor Jubinville has been very transparent. He said, look, he wanted to get me scheduled. He knew it was a school vacation week. He knew there might be people who might not physically be able to be here. And I said, look, I'll follow your guidance. I trust your judgment on this. Whatever you think is best, for my nomination and how you want to schedule the hearing.
Not about scheduling. That's a separate issue. I'm talking about in terms of the counselors that have met with you and talked with you. Would you agree with me? They've all been professional and have asked appropriate questions for a judicial nominee.
Of course I do. Yes, 100%.
Okay, fair enough. Now, I want to talk to you just a little bit about 58A hearings, which I know you're very familiar with. My first question, you come from the background of a prosecutor, okay? And I'm going to ask you if you feel that there are too many motions to have people held, both in the district and superior court, as dangerous.
Well, I think that can definitely be a concern. That can definitely be a concern. I don't have any data or statistics in front of me, but I think there can be a tendency, and this is where you would probably have a concern, is that use an expression. Sometimes that 58A can be like a shiny new toy for prosecutors.
I've never heard that before, but I'll use it in the future.
And at the end of the day, Counselor, you still have to be able to present the evidence. I believe the standard on 58A is clear and convincing evidence has to be presented that the person may present a danger to the community. And look, if they're overused.
And there are no other alternatives to
incarceration. Thank you. Correct. And look, all I can say is, if I'm in a busy first session or an arraignment session in Superior Court, and I get the sense that they're being overused, or it's a tool in a prosecutor's toolbox that's being overused or misused, I would be sure to take some action on it.
Should they be used as a punitive measure? Because it seems to me, more in the district court than the Superior Court where you're going, that they're almost used as a pretrial punitive measure. Should that happen?
No, it shouldn't happen. I mean, everything, whenever a pleading like that is filed and, someone's liberty is at stake, as a judge, whether you're in district court or Superior Court, you want to make sure that, look, this is not a punitive measure. It's based on the evidence, the credible evidence that can be presented to a court, whether it's through live testimony or police reports.
Okay, and police reports are a problem because they contain a lot of hearsay. I know it's admissible, but you can't weigh the credibility of a witness based on what is written in a police report. Fair to say?
Yep, sure, fair to say. And as a judge, I mean, I think you could request, look, you're not going to accept just the four corners of a police report or an affidavit, that you're going to require some live testimony so that you can, get a better assessment, of what a witness or what the state of the evidence might be if a prosecutor is moving on a dangerousness hearing.
Okay, and I'll go back to my original question. Do you think that they are overused by prosecutors?
I don't.
I know you're a prosecutor.
I am.
For a while.
I haven't been in district court in probably 26 years. So
I understand.
I'll take your word for it that they can be overused, and that is definitely a concern.
And do you know what happens when they're overused? A young prosecutor usually files a motion in the case. And what happens to that defendant as soon as they file a motion?
Well, I don't know, but I'll tell you what I do know. What happens if...
I can tell you, they're taken into custody for 3 days.
And Okay.
Sometimes they're taken into custody on a case that they would never do any time on. And then 3 days later, the prosecutor stands up and says, we can agree to conditions of release. But then their liberty was taken away. They're put in a cage for 3 days while they're awaiting a decision on this. Do you think that's right? Happens all over the state all the time.
Well, I mean, my practice has been limited to Suffolk County, so I'm not going to doubt it. I know you have a very busy, practice and you appear frequently in the district court, so I'm not going to doubt that. But I'm telling you, my feeling is that if I were in a session and I felt, the tendency if a prosecutor overuses that tool, moving for dangerousness, I think it has the tendency to really lose its effect. And
I lost you. I don't know if you folks can hear me. I'll sign back on.
you know,
John,
It
I don't know
appears
if you can. I don't know if you folks can hear me, but I lost.
Terry, it was the nominee was for
exemplary for this position. And
I'm back on if you can hear me. I lost you for a moment.
Go ahead.
Okay. Anyway, I'm gonna cut to the chase. Have you read the governor's bill on 58 days to expand their use?
It's not a joke. We shouldn't allow it.
I don't know. I haven't read it recently, Counselor. I'll tell you this. When I was district attorney back in 2018, I did testify before the Judiciary Committee in favor of that bill back, I think it was in 2018, I'm fairly certain. Late 2018.
There are parts of that bill that we all agree with, dealing with things like child pornography and child abuse cases. I don't have an issue with that portion of it. But what about the fact that a prosecutor can walk into court on any given day during the course of a trial for whatever reason and file a 58A for a dangerousness hearing? Do you think that should happen? Because that's what the bill says.
Meaning after the date of arraignment?
Yep. And then the person's locked up again for 3 days, away from their family, away from their homes, away from their jobs.
Yeah, I don't know if, I haven't read the bill, but I don't know if.
Well, you read it.
Does it require a change in circumstances? I would imagine there would have to be some change in circumstances that would have to be presented to the court after.
The change in circumstances is always there on a bail issue. You can always revisit bail if there's some kind of change in circumstances. Agreed?
I'm not following.
Well, if for example, if somebody gets arrested while they're on bail, you can move for a bail revocation, right?
Right. Okay.
If somebody violates the terms of their release, you can always revoke their bail, right?
Correct.
So why do we need another tool that allows them to automatically be held for 3 days, put in a cage for 3 days? Because for whatever reason, a prosecutor feels that somebody's not in compliance or feels that it's appropriate to bring a dangerousness hearing later, a motion for dangerousness later in the process. Why do we have to change that?
Trying to be responsive as I can to the question, and you cut out for a little bit, but,
Yeah, by the way, this is probably the second time I've appeared on WebEx. I don't like it. I'm not going to do it again. I don't agree with it. I only did it because of the unusual circumstance where we have a hearing on school vacation week, and I apologize again for that, but go ahead.
Apology necessary. I mean, to me, if I'm sitting in a session and, there's an arraignment and 3 days later, someone's moving for dangerousness, I just think it goes without saying that there has to be some significant change in circumstances for the prosecution to meet its burden.
Okay, but they don't have to meet their burden on that day. They only have to file a motion, and then you're holding them for 3 days.
Oh, until the hearing can be scheduled?
Yeah.
Okay.
You think that's right? most judges take the position they have no discretion.
I don't know, it's a tough question.
I don't think it's.
I'm sorry, but I really don't know how to
I
answer
don't think
that
it's
one.
a tough question. I think it's an easy answer, John. I think the answer is very simple. That should not be part of the bill. No, if somebody is dangerous at the beginning of the case, they file a motion at the beginning of the case. I don't agree the person should necessarily be held absent without a very strong, valid reason. And then you can have your hearing. But to do it during the process of the case going through the process, I completely disagree with this. Already remedies in place to handle that situation. But that's just my view. All of that said, you don't have to comment on any further. All that said, as I indicated earlier, I've known you for decades. You are one of the most decent human beings I've ever met in my life. You're one of the finest lawyers I ever met in my life, and you're probably one of the most reasonable people I ever met in my life. And you are going, and certainly in my professional life, and you are going to be a great Superior Court judge, and I'll be voting for you next week. Thank you, Mr. Chairman.
Thank you, Counselor. Counselor Duff.
Thank you very much. Yeah, as I said, you know, your resume and background, it says Superior Court all over it to me. You could serve in many capacities in our judicial system, but to me, this is just a great fit. You know, you've worked on major felony cases. Have you had any work on labor disputes or things like that?
No.
Injunctive relief and things like that, no. And do you think you don't know whether you're gonna be in a civil or a.
I imagine, Counselor, that pretty soon, if I'm lucky enough to get confirmed next week, that in a fairly short time after I'm sworn in, I'll wind up in a civil session. And I will do what I've done over the course of my career. I will work hard. I will work hard to understand the issues, understand the law, be able to apply the law to the facts, and rely on my colleagues, which is what I did, you know, for many years, and continue to do to this day when there's something that comes across my desk that I'm not entirely familiar with. So to be sure, there's going to be a pretty steep learning curve. I'm not going to sit here and offer testimony that I'm going to be adept from day one in a civil session. It's going to require a lot of hard work, and there's going to be a steep learning curve, but I'm up to the challenge.
I believe you are, and I don't expect, it would be nice if we got somebody came in with every single thing. But, you know, that's the unicorn, and we don't always get that, and I don't expect it. What I hope for, and what I do expect, and I'm hopeful with you, is that you are open-minded, you're clearly intellectually curious, you ask questions. I find, you know, I'm not an attorney, I'm a public policy person, the law I worked on when I was in DC was telecommunications and very technical intellectual property things and stuff like that. So this is different. But and all of us love, you know, the felony and the criminal stuff. It's exciting in so many ways and everything. But the grit in the detail, to me, especially in the labor stuff, in civil is fascinating. I sat on a jury for a civil case in Superior Court. It was so educational. Absolutely fascinating stuff. What I would ask of you, if you do ascend to the bench, is that you're mindful and careful with your jury instructions, no matter what session you're in. I have a constituent whose father was a police officer and brutally murdered while off duty, assisting a citizen. And this happened many years ago, but it happened when this fellow was a teenager, and he's a grown man now. It has affected his life and his children's life forever. This man's murderer got off on a technicality because the jury was not given the right instructions. And then, unfortunately, went on to murder other people. He is a man, a constituent that I stay in touch with. He is very different than I am. He thinks differently. His political views are very different. But he brings to my attention things that need to be brought to my attention because he thinks differently. And he's made me think differently. And I appreciate that because we're not all the same, nor should we be, how boring would the world be. I'm not somebody who really cares about sensation. I don't like hearing all the crazy stuff, and it's just not, I want everything just to be, but I do ask you to be, and I think by your nature that you would be, but try to be mindful while you're on the bench if you ascend to it. It's not just the life of the person there. It's, this murder that happened in the unintended consequence because of a verbal instruction that was not done with malice. It was a mistake. It has affected generations. And that is the ominous responsibility of being a judge. Now, it seems to me from the testimony of folks who've dealt with you in times of deep and serious crisis that you have that mindfulness about you. What I do ask of you and your family, in your support that's in this room today, is that they continue to support you emotionally, spiritually, in every way they can, because you have already had a career where you have seen and dealt with horrific things. Bless you for that, and thank you for all of you that do that work, because I don't know that I could endure it myself. But you're about maybe embarking on something even deeper than that. And it is important that you stay strong and that you have the support of your family and community. And you may make an unpopular decision at some point. You may make a mistake. But more than that, you might say something or do something that people don't understand because they didn't see the evidence that you saw, because you're the judge. Just like you fellas that are in the DA's office and everything. We're not privy, nor should we be. That's why we have you. Stuff. And in my district, we had a Superior Court judge who made a ruling that was very unpopular. I'm not sure I agreed with it, but he's the judge. He was the judge. People picketed in front of the court. People picketed in front of his home. They threatened him. They threatened his family. They threatened the employees of that court. And I think that's disgraceful. I think that's disgraceful. And I think it should not be done. You can disagree with somebody in a different manner than that. I spent an entire day in Salem Superior Court speaking to every single employee about, frankly, the trauma they had been subjected to from a bunch of protesters who just didn't understand or like a decision. It's democracy, right? Mm-hmm. And be ready for that. And your family needs to be ready to support you in that. And that is something that, because I witnessed it and I saw what it did to people that I consider that's one of my courts, I'm very protective of it. And like I said, I don't know why the judge said what he did or did what he did. It doesn't matter. Separation of powers. It's what we're based on. Oldest constitution in the world, right here in Massachusetts. It's why we are the best. It's why, despite what people say about this council, this is the best way of doing it. Some people might like histrionics. Some people might like drama. Some people might like other things. But at the end of the day, we are charged with putting the best people that we can that are presented to us forward. And I think you are a fine candidate.
Thank you.
I really do. Everything I've heard about you, the one flaw that you have is you have not been to Greece. And your family came here, and I urge you to rectify that issue. And I'm sure I've gone over my time with my diatribe, but thank you, Mr. Chair.
Thank you, Counselor.
Counselor Hurley, are you on the, whatever it is?
I'm I'm on WebEx. I don't know if anybody can see me or not. Something's been
We can hear you. Go
bad
ahead.
today.
Go ahead.
Well, in any event, one of the reasons that we changed the rules and I supported it was because you could have one counselor literally taking up 2 hours with questions and speeches while everybody else just sat there. And I'm the last one before Counselor Jubinville to be able to ask questions. In your case, after having reviewed your application and having checked you out with some folks down in the Boston area, there is no doubt, there is no question that you are a superb candidate and that you're going to do a great job. So I really don't have any questions for you. And my only comment would be that it's not very often that I hear Bob Jubinville saying nice things about prosecutors.
True
But in
that.
this particular case, he was ecstatic, thought that you were going to do a great job, and for Counselor Jubinville to cross to the other side momentarily in support of a prosecutor is pretty impressive in my book. So I don't have any questions. I think you're going to do a great job, and I'm going to vote for you. Thank you.
Thank you, Counselor.
Thank you, Counselor. That's all we got, right? Yes. So let me just follow up a little bit on Counselor Kennedy's dangerousness hearing topic. What I find in some counties is a person will be arrested and at arraignment, they file a motion for the dangerousness. They're held for 3 days. And in some cases, it's allowed and they're held for 4 months. And what I find, the cases aren't that complicated, but some DA's offices wait until the last couple of weeks of that 4 months before they get the indictment. And then, of course, they're arraigned in the indictment and a whole new dangerousness hearing is asked for. And then the person, if they're held for 6 months. So it seems to be in some counties happening all too often that they're getting 10 months of incarceration out of it by playing the system that way. So I know you as a judge don't have a lot of say in that once they file it and they're held for the 3 days. But I'd ask you to take into consideration if that scenario happens as to whether or not there's more of a chance that somebody would be released on some sort of conditions. If you see that happening in the county you happen to be sitting in. It can't just be by happenstance, in my opinion anyway. The other pet peeve I have is the guidelines in the Superior Court. Or just the topic of guidelines. So the reason why I'm not a fan of guidelines is I've seen, well, probably 20 years or more of the draconian nature of guidelines as was done in our federal system. And I don't think there's many people that would disagree with me in saying that they were used like a sledgehammer to people, that people will put in jail. I know of one case where a fellow with no record got involved in selling marijuana and his business flourished, so did the marijuana. And under the guidelines, he spent 18 and a half years in the federal prison for that. And with all of that that's happened down in that building by the water, I say, why would we ever bring a system like that into our system? I don't know how you feel about guidelines. Maybe you want to tell us.
Well, that's what they've been in Massachusetts since I've been a prosecutor is guidelines. There's no statutory scheme, sentencing scheme that has to be followed. So, where there's no minimum mandatory involved, it's still a discretionary call for the judge on sentencing. We still do have minimum mandatory. So, until there's some type of legislative action addressing the crimes that do have minimum mandatory sentences, I would be constrained. I can't abrogate my duty as a judge. I have to follow the law. But I think on those cases that don't have minimum mandatories, I have a wide range of discretion, and I can learn a lot from a defense attorney and in probation about a particular individual before any type of sentence is imposed.
Judge Harrington in the federal court, my opinion, a wonderful judge, refused to take criminal cases because in those years you had to follow guidelines. And he refused to sentence anybody under them. He said, we've been sentencing people since this started in 1780 by going through different topics like his record and his background and the victim and the crime, and all of those things were into the pot. And he said that he wanted to continue that system. So guidelines, as I understand them, are to make somebody that commits a crime, A, in Suffolk County, with no record, get sentenced. And that person who commits the same crime in Pittsfield with no record gets the same sentence. So, to me, one size has never fit all.
I would agree with that, Counselor. And one of the things, one of the good things about my job when I was chief trial counsel and when Pat Hagan was the first assistant is we would do a lot of the screening on particular cases. So, under District Attorney Conley, he gave us the discretion to do that. So, a lot of the times we would screen out cases where we didn't feel that they were appropriate for a minimum mandatory sentence. There was just no justification for it. A perfect example of that is, a female drug trafficker who's actually the lowest rung on the ladder, acting as the mule, and she's trafficking, 100 grams of heroin or fentanyl, and is looking at, a double-digit minimum mandatory. Our approach, for many years on many cases is like, look, we have to make an accurate charging decision now before this ever gets into the courtroom, because once you get into the courtroom, you're going to tie the judge's hands. So I don't know, I don't know what other counties do. I know that, under District Attorney Conley, we were very flexible, had a lot of flexibility, and had a lot of ability to exercise discretion on charging before the case was ever indicted. And that's where, I wouldn't just say our office. I think we did a really good job of it. Of course, I'm biased, but I think every office has to put a premium on charging decisions.
Unfortunately,
you have your stats and you see what happens in the courtroom, and I'm not going to sit here and quarrel with you on those cases that you've seen. They're true, and a lot of them are terrible outcomes. What we never got credit for is the cases that are actually screened out, where you can get the case into the system, where there'll be two things accomplished. There'll be a level of accountability, but there'll be, you'll leave the judge with some wiggle room to fashion an appropriate sentence. So, your point's well taken.
Unfortunately, not all counties do that. They're quick to charge the highest they can charge and bind a judge's hands. Unfortunately. But they ran up against a Superior Court judge who saw somebody standing in front of her. She's a little bit of a judge, about 5 feet tall. And she said, this person it is not fair for me to have to sentence this person to 10 years minimum mandatory sentence. And I've heard people sit in the chair you're in say to me, oh, I'm going to be fair, I'm going to be fair. Well, she did something about it when she saw and said to herself, this is highly unfair for me to do this. She didn't do it. She sentenced him to 2 years in the House of Correction. It was appealed, obviously, and it was overturned, and the person was sentenced to the 10 years by another judge. But think about it. If judges did that in the Superior Court, it wouldn't be a day or 48 hours before the legislature did something about it. Unfortunately, we don't have the caliber of courage in a lot of judges to do something like that. And of course, she couldn't be fired for that or suspended. But she made a statement, and I would, if more judges made that statement, there wouldn't be some of these unfair sentences just because of overcharging. The thing with the guidelines, though, even though they say they're advisory, it seems to me that they are the starting point of the discussion with the judge. If they're good for the prosecutors, they use them. If they're good for the defense lawyers, they use them. But they're the starting point, it seems to me. Once they're thrown out in the mix, you know, if the DA says, well, the guidelines are 5 years, now we're talking about that as far as where we go from there. And I know they're advisory, but me, if I was a judge, and I'm only talking about me, if they were brought up, I'd say, whoa, I don't want to hear them. Tell me why, what your sentence is, and tell me why. And the same with the defense attorney. I don't want any guidelines. I can sentence somebody without guidelines. You know, I've been practicing a long time. I've never walked into a clerk's office and saw a big file sitting there that was kind of shop worn. And I say to the clerk, oh, what's this? Well, we're waiting that case. We just can't figure out how to sentence the guy. I've never seen that. I don't think it's ever happened in the history of our court system. Any event, that's my take on that. You know, I have a very strong opinion of you. You were a great lawyer. Tried many cases, and one of the attributes of a good judge, according to Judge Hennessy, the Superior Court chief many years ago, he wrote a book about it, and he said one of the best qualities that makes a judge is litigation experience in a courtroom. You have that. You have something better than that. You have kindness. You don't take pride in sending people to jail. Sometimes it's got to be done. Unlike 2 DAs I saw one day many years ago after a verdict of guilty, high-five each other in the courtroom, as if this was some sort of sporting event. And you know and I know it isn't. There's no winners in those rooms. There's losers. Everybody loses in there. But you have never taken pleasure in that or bragged about your sending people to jail, which I think is a wonderful quality. And you're going into a new role now. And a lot of your friends on the DA's office may come before you, and you have to now rule in a different way sometimes. And I have no doubt in my mind that you will do that. So with that said, I think you're going to be a wonderful judge, and we'll, I think, vote on you next week.
Counselor.
It'll be my pleasure to vote yes. Okay, hearing adjourned. Hearing adjourned.
The letters into the record that we received.
Hearing adjourned. Thank you.
The letters that we received.
It's submitted.